All right, everybody, welcome to Cyber Bulls. It feels like we're actually in a do or die moment. We've got two big events that are coming up. Right next week at June 13th, this is going to be the big shareholder vote. And then, of course, there's the robo-taxi event. Forward to June 13th, another big event that occurred is Amy Steffen, a longtime shareholder, actually filed a motion to be included as part of this legal battle. And she's representing the shareholders. We're going to talk about that today. We've got special guest with us, Richard Hofman. He's a litigator, lawyer, so he's got special knowledge, understanding how these lawsuits work. We've got, of course, Alexandra Mertz, and we got Jeff Lutz, the Bulls with us. Welcome, everybody.
Hi.
Hey.
Great to be with you.
Richard is not in the Alps. He's not.
I just
It's a fake screen.
It's a fake screen. All right, so let's start with Amy Steffen. This is what she dropped yesterday. She said, I've retained counsel to appear in the Delaware Court of Chancery to challenge the plaintiff's fee request in the Tornetta and Musk versus Musk lawsuit. I voted for the CEO Performance Award in 2018 and voted for the ratification now. And then she's clarifying that at this point, she is not going to be able to be, because she's active in the case, she'll refrain from commenting here. So I'd like to have this group here explain the significance of what she's done here and the details of what's happened. But this is important, right? Because now she's representing the shareholders. Before this, shareholders were not in the court of record. Now, a lot of things that the work that you guys have all been doing is now going to be part of the record. And she's representing shareholders. That wasn't done before. And the legal counsel she obtained was just powerhouse. The company and the product don't look at the quarterly stock movement.
A very realistic bull, questioning certain decisions.
The rational bull. We enjoy listening to bears.
You're looking for the red flags. You're supposed to react.
Let's start with you, Alexandra. Tell us what this is.
I mean, this is absolutely great. I say it to whoever wants to hear it. Amy is a true powerhouse. She's the smartest cookie in town. She's been absolutely stellar the last couple of months in trying to prepare that. So when that judgment came out end of January, beginning of February, I never remember the date, it was clear that us shareholders, we were not considered at all. There was this one shareholder with 9 shares and everything was concentrated on him. And she helped me initiate that survey that close to 6,000 shareholders filled out, where we requested from the board, remember we sent this big package, we requested from the board to reinstate the 2018 compensation package and to move out of Delaware. So that was sent end of February, beginning of March to the board of directors of Tesla, and was now mentioned in this proxy multiple times with details. So that was our order from shareholders to the board to now act. And then the second thing she helped me initiate was those letters to the court. So we had this week, actually, as a public record, the 1,388 letters they've received. They received more than that. But what they did is they worked with Broadridge. We're going to talk about Broadridge certainly later as well. Broadridge is the one also organizing the proxy votes for Tesla, to check whether the people who pretended that they're shareholders were really shareholders. So for all those that they could verify with certainty that they were shareholders, those are the 1,388 letters and 189 emails, and they become public. And remember, initially when she was inundated with these letters, the judge said to Bloomberg that, well, she doesn't know what to do with this thing. What's this? And this is a precedent. I mean, Richard will be able to tell us. There's no other case where 1,388 verified shareholders and 189 verified shareholders for emails wrote all this and explained to the judge that they're shareholders too, most for much more than the 9 shares that the Tornetta had, and they're against her interpretation of what happened. So those became public now. So that was a big jump from her initial position where she had no clue what to do with it, and she wanted to ignore it, and she wanted to ask to counsel both of the plaintiff and Tesla what to do with it. And now suddenly, end of May, they became public. So that's the situation at the moment when Amy's law team decided to jump in. They've been working on this diligently for about 2 months. So the little I know about it, because Amy very quickly, once she had missioned her lawyer, said she can't talk anymore. So I have not a lot of information. But when Amy decided, it was Kristen, Amy, and me who said, we have to do something. We have to consider legal action. We have to get introduced into this case. And it was really Amy's strategy. And we decided that Amy was the strongest shareholder to carry this burden. This is tough for her, and I understand completely why she wants to stay out of the spotlight at the moment, because she can't comment much. She shouldn't comment. The lawyers, Richard is going to confirm that to us, want her to stay quiet. She won't comment much on, or not at all on X. So we have to bring forward what we know, but it's not a lot, because these are very strategical lawyers, and Richard will explain to us who these people are, because they're really the top of their breed. So she reached out to the top lawyer by herself, just called there in that law firm and said, look, we need to do something in this case. I would like you to represent us. And that top lawyer, so she didn't talk to him straight away, but that top lawyer called back in the first hour and said, I want to do that, and we'll do this on contingency. So, obviously, maybe not everybody knows what that means on contingency, meaning they're not going to get paid by Amy. They're going to get paid at the end if they achieve a certain result. And the result is linked to reducing the fees of the plaintiff's attorney. So the mission they have taken on for the moment is to concentrate on the plaintiff's attorney's remuneration, because that's the last outstanding point in that procedure. The judge has, end of January, declared what she thinks about this all, but the one thing that was still open is how much should the plaintiff's attorneys be paid. They moved first and came up with an amount that amounted to a certain number of shares. I think it was 29 million shares, if I recall it right. So depending on the share price, it's about $6 billion. They thought that was very generous from them, because there is a case law that they refer to that's called Sugarland. We're certainly Richard's going to explain this to us much better, where they pretend they could have had even much more. So generously, they would reduce that to only 6 billion, or the equivalent to 6 billion. And Amy's lawyer saying this is just complete crap. This is not the right basis. This is not how this should be calculated. And this is not how it's going to work. So only if these lawyers from Amy arrive to reduce this substantially will they ever be paid. But otherwise, they're not going to be paid. So for Tesla and for us shareholders, this is a win-win situation. And she was very, very clever in building this up. Just want to talk a little bit about Amy, because in the case that's now public, it explains how she was actually a paralegal initially in her professional career, then became a finance professional and holds licenses in finance. So she knows this very well, what we're talking about, and then became the airline pilot that we all know her for. So she has this unique mix of knowing the industry, knowing the legal side of it quite well, being as motivated as you can get. When Amy wants something, beware what's happening. Don't mess with Amy, I always say. So she was, very focused on this, accepted to, because we all love being on X and exchanging and talking and whatever, accepted that she can't do that for quite a while now. And really makes it, possible for all of us. So I want to actually start a support survey, or maybe a change.org page. I haven't really figured it out. And I think I also want to let the vote go by, because we're soliciting other shareholders so much these days, vote, call your friends and families to vote, whatever. If now suddenly they also have to sign up for support for Amy's case, I think it's a bit much. So let's get over next Thursday, and then end of next week or beginning of the other one, we'll set up a support page where other shareholders can sign up because they support this case.
Okay, thank you, Alexandra. So don't mess with Amy. Don't mess with Alexandra. Don't mess with Tesla retail shareholders. What's really amazing, what's impressive is that this is the grassroots effort from retail shareholders stepping up. That's really critical. There's no support or no communication with Tesla regarding this. Let's talk about the legal counsel that Amy was able to get. Let's start with you, Richard. Tell us more about this legal counsel. Who is Munger and who is Joseph Grunfest and Donald Verrilli?
Yeah, so I'm going to take you a little round trip here. So Munger, Tolles & Olson, which is the firm. First of all, Amy, in my interactions, the one thing I noticed above all that she was super sharp, and that always impressed me. So the fact that she got to Munger, Tolles & Olson does not surprise me, because Munger, Tolles & Olson is one of the leading law firms in the United States. Leading being, I'm sure it's in the top 5, and they are amongst the most exclusive in that they only interview kids who graduate from the top law schools if they clerked in the U.S. Supreme Court. So that is a really small number of people in the end. So they get a high caliber of candidate. Alexandra seemed to be more familiar with the individual, so I'll defer to her on that, and then I'll kind of go back and kind of give you my impression of what she filed and something that the judge did beforehand that kind of nobody has spoken about. So I'm going to hand it back to Alexandra to talk about those 2 lawyers.
Perfect. Herbert, if you don't mind, exactly, keep that up. So the key person, the first person she approached because she wanted really to work with him is Joseph Grunfest. So if you want to share with us the next slide, please, Herbert. Because that was the initial discussions that was about the strategy. So he is really well known. He's a professor at Stanford Law School, and and these slides are up on my profile. Has degrees from Yale and from Stanford. Has published lots of law work. I mean, there's a complete parts of law journals that are dedicated from him, and he has founded the Stanford Securities Class Action Clearinghouse. So everything that has to do with security fraud litigation. He was also at the SEC and commissioner. He was a commissioner at the SEC. He has worked with people that were in the options industry. That's actually how my husband still knows all this crowd. And so there is lots of very precise knowledge of a highly reputable person. And the fact that he took this on immediately, like said, I'm going to be there. This was wrong. I want to help set this right, is a very good sign. And then he decided on the law firm that would assist them. And so that is Munger, Tolles & Olson, and I'll let Richard talk a little bit about it. But the leading lawyer in the trio that we have from Munger, Tolles & Olson is Don Verrilli. And he is a very specific person as well. So that's 2 slides further. He was Solicitor General of the United States for 5 years under President Obama. He's a partner at Munger, and he opened their Washington, D.C. office. He also did Yale. He then did Columbia. He was then editor-in-chief of the Columbia Law Review. He clerked, as you just heard, with the U.S. Courts of Appeals judge, and he was also a clerk and associate for the U.S. Supreme Court. And he really brings a high reputation to this whole law case. You have to know that he was the one successfully implementing the Affordable Care Act under Obama. The picture I put higher up is the moment that in front of the Supreme Court, he was announcing the results. That's him. So we're having somebody that is extremely stellar. And then he took 2 of his associates to help him with that. They're both great. They have less experience. And then they needed a Delaware representative, and that is Anthony Rickey from Margrave Law, because you always need to have a local attorney representing you there, right? That's how it works, Richard?
Correct. You need somebody local, and the other attorneys will basically join in. But the bottom line is, kind of to summarize, that this firm will put out excellent work product, and they won't lose because they forgot something or made an error. It's going to be a very polished and well done presented package, and we'll have the best shot we can going in. So whoever made that decision, you have to give props to them, because that was a good choice.
I'd like to add too, right, that we do believe that there is some political kind of a backdrop of why the judge did what they did and all that. But these two are actually Democrats, or they, represented Democrats in a certain way. So, you know what I mean? It's great that that's the case. Then it kind of says, okay, it's not just the two parties fighting each
Completely
other.
agree.
Yeah, well,
Completely
It's
agree.
important.
yeah, Munger, Tolles & Olson's an LA-based firm, so it's coming
In
from
California.
coming from that background.
It is, and like I said, they really worked under Obama, and the little that Amy was allowed to tell me, she said, "This is really old school America. This is not about politics. This is about right or wrong. This is about that something was wrong, and we want to help. We're not playing politics here. Maybe the other side is playing politics, but we're not."
You know what? It needs to go to the Supreme Court at this point. This is anti-capitalism. This is anti-American. This is impacting every business. You can't let this happen. If this happens, and it continues to happen, it will continue to happen. Tesla, not only Tesla, but other companies will have continuous lawsuits because these guys are going to make $5 billion out of this.
Well,
They're gonna keep
I guarantee, if in fact there's some award like that, it will make it up, because there'll be a question of the
Completely agree.
proportionality of the award. So
Yeah.
it will. If it's somewhere like it's marginal in the whatever, if it's $44 million, because I saw those numbers, if it's $44 million, that's not going to be taken up by a Supreme Court. It's going to be
Exactly.
close enough, whether it's way too much. But I kind of wanted to touch on a few things just to put it in context. Remember, this case, it's all about plaintiff's attorney's fees. This case wouldn't have been brought but for the fact the plaintiff's attorneys thought they could get a big score. There's
That's
no
exactly
other
it.
reason. No other reason. And today, it's even more so. They have the most to lose in the vote in Texas, the vote to go to Texas. And if, in fact, this is reduced, they're the only player in town. They're the only one who's benefiting from this. Nobody else benefits. So it's a charade to pretend anything other than that it's just an attempt by plaintiff's attorneys. And there may be times that it's justified. In this, it's seems to be purely a grab for money. That's it. Nothing more than that.
I agree with you. I actually have a question on that, Richard. Does the plaintiff himself get anything?
He
Does
gets usually a bonus. In the past, he's gotten like $10,000.
I know. I saw that in his
He's
other.
done this before.
Yeah.
But yeah, that's generally they give them like $10,000 or $15,000 as a bonus. That's what they're getting. So they have no interest really in the outcome, really, because they're just going to get a small number. But what's also interesting is this judge, in an opinion, McCormick, who obviously is not a friend of ours, she said, in kind of discussing attorneys' fees, she said plaintiffs' attorneys no longer are going to get these windfall awards unless they provide shareholders a real benefit. Those are her words. And if the grand scheme of things, when we look at this case, there is no benefit to zero. There's no benefit to shareholders. There's only a detriment to shareholders based on the fact that if there has to be paid, if something has to be paid, there's no benefit to shareholders otherwise.
And even less benefit
Negative.
once the plaintiff's attorneys are paid. Even less.
Right, because everybody gets.
Yeah.
I think in Amy's brief they said that everybody gets diluted 1%. I think that was the conclusion. But what's interesting is, and I kind of slipped in on, I think it's May 28th, the judge. So what happened is, between when this motion was filed for attorney's fees, there were a bunch of filings that happened afterwards. And those filings involved basically plaintiffs' attorneys trying to make sure that Tesla didn't do something to circumvent their rights to recover in this lawsuit in Delaware. And there were briefs filed between the parties. And eventually, and what happened is they wanted to stop Tesla from contesting it, those kind of conclusions. In the end, what happened is the judge said, I'm not going to grant the motions of plaintiff because it appears Tesla's not going to contest this particular proceeding in Texas. And I'm going to rely upon the integrity of the attorneys for Tesla to tell me otherwise. And that was out on May 28th. We haven't seen Tesla's response yet to that brief, to that statement, because they haven't filed their opposing brief yet, but it'll be interesting to see what the Tesla lawyers, how they respond. Because in Amy's opposition or objection, they do in fact kind of reference that the vote could basically get rid of the ruling by the court by Judge McCormick. So are you both still there?
Oh yeah, we're here.
Okay. I didn't see you. I didn't see it. So she had an interaction with everybody. She put Tesla lawyers on notice, and they haven't responded yet. And she was kind of, honestly, she's a little pissy about it. She almost said it in a sarcastic, you're reading something somebody wrote. So I'm guessing an intention. But the way she wrote, it said, "You're not going to contest what I'm doing here. And if you are, you better tell me now, or we're going to have a problem." It was interesting language. Then Amy filed her brief after that. Tesla has not filed their brief, or if they have filed their brief, it's not been released yet because there is some confidentiality agreements between the parties. So I think they submit, and then there's some redaction period, and then it's posted. That's why the dates sometimes are off. But basically, what is at issue here, and what's referenced in Amy's brief, is what's the method of calculation of attorney's fees? So in Delaware, the method they've used is called the benefit, the conferred benefit that's provided. So how do you measure that? Well, the example is there was a Dell class action in 2022 that was settled for $1 billion. So the class actually got $1 billion in cash. The court, in some process, and it was on the eve of trial, so it was at the end of the case, they gave them approximately 26.6% of that $1 billion. They said that was a reasonable fee because it's the end of the case, you got cash, and so there was obviously a benefit conferred upon the class. It's $1 billion. Even though 26.6 is a big deal, we can make a deal of it. So their standard is that conferred benefit, if you could figure it out, and then you might make modifications based upon the complexity, where it was in the case, and all those factors. So that's kind of the Delaware approach. But it also cannot be a windfall. So just because of circumstances, you can't, even though it qualifies under the first standard, you can't give somebody excessive compensation because that's not allowed too. So the way it's argued in Amy's brief, they basically give three different arguments. In terms of the benefit conferred, if that's the standard, it's impossible really to ascertain because under Delaware law, the benefit conferred has to be by you, the attorneys, not by the company. And in this case, the market cap appreciation in Tesla was caused by Tesla, directly Elon, not by the attorneys doing anything. So therefore, they're arguing that's not a proper way of evaluating the benefit, the real benefit. And the benefit, we don't even know that if that's the real benefit. And ultimately, if there was a benefit conferred and we're going to make an evaluation on that, we should use the option valuation, and then we should discount that because there was a couple reasons you could discount on that, and then take a percentage of that, and that would be your attorney's fee award. Now that probably would be in the less than 100 million, I'm guessing, but somewhere in that ballpark, not anywhere near close to that. A second method is, and this is what they use in California, it's called the lodestar method. And what you do is you basically take the number of hours worked, you multiply it by what the hour is for someone of your level in that jurisdiction. You multiply them together. You might make an adjustment based, again, where you are in the case, the difficulty, who else is doing it, and that's your calculation. And so I think when I did it, because I actually did this when we originally talked about this, and I think at that time, I was just figuring it straight time, and it was something like 20 million, maybe 15 million, something like that. In Amy's brief, because they had a bunch of experts provide support for their arguments. So, for example, they went back and looked at the historical record of these particular multipliers in securities litigation and see what the range was. And the range was something on the order of, let's say, 1.5 to 3.7, I think. So any multiple of the hours at times your rate times whatever that additional number was a way you could calculate attorney's fees. And that gave you a number, I think, between 22 and like 45 million. And then the last way was something called quantum merit. And by the way, this is something that Elon might have as a remedy against Tesla, because we haven't talked about it. What happens if Elon gets nothing? He was operating, I think, yeah, I've heard that. I think I've heard this on this show. He was operating under the understanding he was going to get paid. He wasn't doing this for free. So even if there was no valid contract, there's a concept in law called quantum merit, and it just means you're entitled to the reasonable value of your services. So you would put on some evidence and make a calculation. Would it be substantially more than like the lodestar times some factor? Probably not. So again, it would probably be in the range of 22 to 40 million. That's what Amy's counsel, and again, I'm not speaking for them because I've never spoken to them, so this is my review of their paperwork and my non-legal advice. But that's kind of what they're saying, that if you rule in favor of awarding attorney's fees, then award in the area of 20 to 40. That would seem to be a reasonable sum under the standards across the nation.
So we're very far from the 6 billion they're hoping for.
Yes.
And also, let's say it would get to that level, because we're now in these critical last 6 to 8 weeks until the final judgment, right? This is the only thing we're expecting Tesla's response. Tesla hasn't responded yet. That's due in the next couple of days.
Yeah.
And then there may be a hearing, or she may go straight to her final judgment. If the final judgment is in this reasonable range of 20 to 40 million dollars, do you think it is still worth for Tesla to go in appeal?
Well, they could do both, right? They could pay the money, they could pay the fees and still contest the findings. And they would be perfectly protected. They could do whatever they want. There'd be no
I think that's what's important to explain. I agree with you.
Yeah.
I think the whole case, I mean, the money is one side and the money is painful, and I'm very happy that Amy is doing that. But I think the other point about this case is that the judge pretends that the board was weak, that the board was not, independent enough and had issues. And I just hope that Tesla doesn't let that stand, because if it's, first of all, it's not true. Even if it would be true, and again, it's not true, but even if it would be true, you can't just make up that these people were weak. I don't know what she's basing that on, but if this judgment is the only and last word out there, it creates a precedent that will allow to attack Tesla's board for anything between 2018 and now, right? And so that's a huge lapse of time, and I rather have them cleared that up.
Yeah, unfortunately, from a practical standpoint, unfortunately, you'd want a bigger, like, obscene judgment, because that's easier to appeal. Something that's kind of less. And, a judge is going to try, if a judge doesn't want to get appealed, that's a consideration they look for.
The lawyer
they're manufacturing. Really, it happens. They're trying to find a sweet spot. Yeah, I could put it here and I could probably survive. And that will go into consideration, because they're going to reflect on the same things we're reflecting upon. But it shouldn't, I agree with you, it shouldn't impact your ability to contest an unfair ruling. But it does. And unfortunately, in reality, it does.
Yeah, I think there's profound impact too, just like in terms of how the United States looks, in terms of a place to do business. Like something like this could happen to arguably the greatest innovator in the world right now, and and the company doing the greatest. The fact that this could, I mean, just go back to the core of this original suit, which is we don't believe, or the judge's ruling that like the board was quote unquote weak in constructing this pay package, and he's running away with it, and shareholders were damaged as a result. Meanwhile, the company 11x'd in a shorter period of time than the actual milestones allowed for. That's the actual result. Like that's what actually happened. Like that's it. I mean, there's no contesting that. But a lawsuit was allowed to be brought. And now even the 20 to 40 million to me is outrageous given the core of this lawsuit. I mean, in the end, shareholders, the company is 11x bigger than what it was at the start of this, and shareholders were not damaged as a result. And quite frankly, if you look at the forward vision of the company and how it's set up to make another, gigantic move. And this all comes from the CEO. So I'm dumbfounded, like how the U.S. would look, kind of from the outside looking. And there's other things going on in politics too, where there's prominent figures being sued just every which way, and it's looking at just very very litigious. And I go back to this comment, like if this could happen to Elon and his comp package, could this happen to others? And I've seen some of the arguments about it, and it doesn't work. It doesn't A/B test when you compare it, and we'll talk a little bit more about that later. Just wanted to make a quick comment there.
Yeah, I mean, I've appeared in front of a lot of judges. I have a lot of qualms with a lot of judges because I just don't agree with them. But there's been a relatively small number where I thought there was something fishy going on, that it just didn't, there was something that didn't add up. But it's happened. It's not like it hasn't happened. And I had one client once who he was operating a cellular business. This kind of gives you like what could happen. He was operating a cellular business in LA. A much bigger competitor set him up. So the cops came in midday to basically, like, if you know LA, it would be like on Wilshire Boulevard at noon, and 50 squad cars coming from the store so nobody can miss it. And found nothing, by the way. But during the discussion, one of the cops went up to my client and said, listen, give me $50,000 and I'll take care of it for you.
What?
Yeah, that was a direct payoff. Now I've heard like a couple others, and there was no reason for my client not to tell me. And maybe it wasn't like a low-level guy. It was more of like a sergeant type guy, so had a little more experience. But when I heard it, wow, that made me think, wow, this is not the first time this guy's made that offer before to be able to do it. But I've had a couple times, I didn't believe it. I've had a couple times clients tell me that they could buy off the judge. That told me that. I didn't believe it, but I believe it happens. So McCormick is the judge. She obviously has something against Elon. Should that come into her decision-making? Of course not. But has it? Of course it has.
But don't you think she should have resigned it herself from the beginning? I mean, given her past with Elon cases were always negative, always, never even neutral, it would have been, in my view, the right thing to do. And I'm actually surprised that nobody called for it.
Yeah. So I don't know. Yeah, I don't remember the order. I don't know why they elected not to. But like if I go to court, first judge, so I go to state court. It's in state court in Delaware. So I presume they have similar setup. If I file a lawsuit, the first judge I get, if I don't like that judge for any reason, I can get rid of that judge. Any reason. Judge number 2, now I have to have cause to get rid of the judge. And from that point, the concern you have when you do that is if I get rid of judge number 1, now does everybody in the courthouse know that I've got rid of judge 1? They're all gonna be pissed off at me. So I don't know, in Elon's case, they've been in front of this judge, but they know who else is around, and maybe they didn't want to risk it. They, kind of knew, they knew who they had.
And she's the head of the Chancery Court, right? So it's not as you would have gotten a lower level judge, and that's probably not the most politically correct thing to do, getting rid of the head the Chancery Court to drop it down.
But I guarantee you that there was a conversation about that very thing when the case was started. Are we going to get a fair shake?
Yeah.
I mean, she took
Well, we
the
did- we
case
did not.
while she was ruling on Elon's purchase of Twitter and essentially
Yep.
ruling against his public wishes of trying to actually get out of the deal, right, wrong, or indifferent, or at least be able to pay some sort of breakup fee. And basically, you know, the result of that was the worst possible outcome, at least for Elon at that time.
Well, you too.
And then she,
Yeah, but I think it was reversed though. I think it was reversed. I think this case preceded the Twitter case. And
The start of it, yes.
yeah,
the
so they
start of it.
probably could have. He probably could have gotten out of the Twitter case. Her being the judge for the Twitter
Well,
case.
now I have a question for you, because
Yeah.
I do believe we will win the compensation next Thursday. Then the compensation has to go back to Delaware, a new procedure called 204, right? 204 reinstatement of shareholder decisions that were put out of place have to be put back into place, or something like that. It's more elegant than I know. Do you think she's gonna try to get that case as well?
If there's a lawsuit filed, yeah, I think she will. If she can.
But it's not a lawsuit. Well, the lawsuit will be the 204 is a formal procedure that has to be done at the court, right? It's not that's a hearing, and normally if you have all the formalities in place, you get it. But if then somebody objects, and the Tornetta plaintiff's attorney has already said he's going to object,
yeah,
then
you're going to have two. I think you're going to have two things. If the pay package is reinstituted, you'll have a new lawsuit filed to challenge the new pay package, and you'll have an objection maybe to the proceedings leading up to the end of this pay package. So you could have kind of two going on at the same time.
Yeah, how does
And
this
then you're going
purchase
to have,
end?
eventually you're going to have Texas taking jurisdiction over this, and because that was part of that letter, you know, where I started that's
Beginning of-
her
end of-
saying, you're not going to go to Texas and take this away from me. I know that everything after is yours, but this is mine. But I have a sneaky suspicion that there is going to be litigation involving who has jurisdiction.
I don't agree. This morning on CNBC, Robin Denholm restated that this case until the end will stay in Delaware.
I know.
And, so
I know.
I don't think they're going to take that risk. I mean, not with her publicly stating that.
Yeah,
She was great, by the way.
I don't think it's the case. I've heard the language before. There was something about the language that I didn't find conclusive enough. So it didn't say like all the issues are going to be resolved in Delaware. It was specific to the case. So there may be future actions and other cases that deal or could be relevant to these issues. And I don't think they foreclose themselves from relying upon Texas to resolve
Okay,
that.
well, I hear you, because I mean, the sooner we're in Texas, the sooner this is all going to calm down. So I hope you're right.
And obviously, this is kind of a case of first impression, right? Like this kind of a award. And you
But did you see at what speed plaintiff's attorney tried to insert that motion to make sure that this whole thing stays in Delaware, because that's where they want to have it?
Yeah.
I mean, that was the quickest thing that.
Yeah, they filed like 4 motions after the attorney
exactly.
fee motion to make sure this is going to be decided here and nowhere else, and can't take it to
And
Texas.
us, exactly.
Yeah.
Let me ask the panel here where we're all sitting, right? Are you thinking that on June 13th, the vote for the 2018 re-ratification and then the move to Texas, how are you guys feeling about each of those? Let's start with you, Alexandra.
I think the compensation will pass with a 60 to 65% approval. And we're talking about the third standard. So there are 3 standards for the compensation package. In the first 2, Elon and Kimball's votes count, but they are not going to be considered. It's the third one, the toughest one, the least easy one. Still only based on casted votes, but it excludes Kimball and Elon. And on that one, we had in 2018 73%. And I think we were going to have this time between 60 and 65. I mean, this is my gut feeling. I have no inside information. Let's just make this very clear.
And then Texas?
Well, Texas, I think we won't get the quorum. because Texas, we need 1.6 billion votes. In Texas, for Texas votes, there are 2 levels. The first level is all outstanding shares. We need to get 50% plus 1 vote. So from nearly 3.19 billion shares, we need more or less 1.6 billion shares voting for it. And while we're still working on it every day, and it would be a true miracle, I think that's too steep a hill to get to the quorum, to the necessary votes. And then the second part of that is of casted votes. I think for the casted votes, we get it easily, but it's that all outstanding votes that I'm manage my expectation that is not going to pass. Okay, Richard?
Yeah, I was about the latter one. Those brokerages are terrible in terms of effectuating, making it easy for people to do anything, to vote, to get dividends. I was involved recently in a arbitration involving Fidelity. So Fidelity, has a reasonable reputation. Okay. So moving on to the vote, it's Tesla and Elon. So the only appropriate answer is he will prevail with 69% of the vote. Isn't that the only appropriate answer?
Good one. Good. And then Jeff.
Yeah, I'm not sure what percent, but I believe it will prevail. I think people need to vote if they haven't voted still. And on Texas, I would defer to Alexandra as well. I think it is going to be a little bit uphill. I think they're just going to have to keep going at this one until they get it through. But yeah, I hope this, at least this portion of it's done, and the shareholder base expresses confidence in Elon, which I believe they have, and they will.
Then let me just get back a second to Texas. It's actually funny because a lot of these fund managers are also domiciled in Delaware. And I think the overall mood of capitalist America, I'm not saying of everybody in America, but I mean, fund managers capitalist. I mean, if you're a fund manager and you're not capitalist, change your job, right? And if you're in Delaware and you see what's happening in Delaware and you tell yourself, I mean, I probably should sneak out of there as well. Because I don't want to, stay there forever, given what's happening there. You can only vote for it because Tesla is such a symbol now for this whole exodus from Delaware. And let's just make that clear as well. Delaware is going to find a reason or a 9-shareholder plaintiff to question how we move out of there. But we will in the end move out of there. There's no doubt about it, whether with this vote, whether with a future vote, and after another law case. But they want Tesla to be that big horse fighting this fight now. So I do believe we'll have probably more institutions that may not like Elon and express their miscontent or whatever they want to express in the compensation package. I still think we'll get it. But I think for Texas, if they think twice, they're actually for Texas.
Yeah, what's interesting, yesterday there was an announcement that BlackRock and Citadel are moving forward with trying to open a stock exchange in Texas to compete with the New York Stock Exchange. So kind of another migration to Texas.
Okay, so then if I have to ask the question then, why was Robin Dunholm, why was she in CNBC this morning?
She said it very clear. She said it very clearly. She said, I've been touring the world to see institutional investors, but I'm here with you, Andrew, because now I want to address retail. And so this was a pitch to retail investors sitting in front of their screen, watching Squawk Box, and maybe have not voted yet. The thing is, they need, both of those decisions will be questioned in Delaware courts again. Both of them. There is no doubt about it. And they need the highest possible percentage if they pass. So in order to have the highest possible percentage, she's going to fight until the last day. She cannot give up now and say, oh, we just put Tesla Kila up on the website. We're all good. Because, I mean, I know there are people thinking that's not an attitude of a chair of a board. She has to make sure that everybody stays motivated, hands on deck, and continues to vote. To increase that number, I mean, again, my expectation says that Texas doesn't pass, but that the compensation number is as high as possible. And if by any chance Texas passes, that it also passes clearly.
So Tesla put together, released today on the Tesla shop, you could buy this Tesla Aquila, $450 Mexican.
That's mezcal.
Mezcal, not tequila, but yeah.
Different
So
alcohol.
I know.
I have no idea. I never drank neither mezcal nor tequila. Don't please.
Jeff
stay
seems
with
to know
me.
what he's talking about here. When
That's
Jeff
right.
saw-
Jeff,
when Jeff-
the tank. Here we are back. Let's talk about it.
We're going to meet Frank the
So
Tank next week. So, Jeff, you saw this, and this person said this. Judging by the latest drink they have announced today that they're selling in the Tesla shop, it's a done deal. The comp deal has got the votes. I mean, come on, it's coincidence, guys. It's got nothing to do with this. Jeff, you somehow think it might. I don't know. I don't agree.
I don't know. Maybe, you never know. I mean, I think Tesla messages in very strange ways. So we'll find out. Everybody should vote if they haven't voted. I just want to go back to just one more. I mean, there's something else that came out of the interview of Robin Denholm this morning, that Tesla has already reserved the $2.3 billion for the original 2018 compensation package back in 2017, I believe, or 2018. But when I read the judge's ruling, it says the judge noted that the pay package was structured to help Musk achieve the goal of making a good future for humanity, but still found the amount excessively large and unfair to shareholders. So it's just, again, it's bizarre to me. It's 2024, and this ruling comes out in January or whatever. Unfair to shareholders and they've already reserved for the compensation package back 5-6 years ago. I don't understand. If they were to do this compensation package today, it would cost shareholders a lot more. So I just
25.
again, this doesn't pass the common sense test. And she, by the way, she commented on the pay package saying it's an unfathomable sum. So now we're going to have single judges, appointed or not, elected or not, just commenting on how much somebody should be paid. It's completely un-American. It's completely anti-capitalist, and same going back round trip to these attorney fees. I mean, the amount is ridiculous. The amount of the attorney fees first off, any amount would be more than Elon's been compensated, but it would be more than what Tesla actually reserved for the Musk compensation package by 3x. So just coming round trip, I'm really glad that Amy launched this. I think this is great leadership. You're putting yourself out there for a very important cause, representing shareholders. So I'm very appreciative of it. Very appreciative of the work that Alexandra is doing on the vote and that awareness, and really on the show, Richard's legal advice. I think it's been super helpful just to kind of, for me even, to walk through this. So thank you.
What's very interesting is you've got people like Amy, Alexandra, Gail Alfar, K10, so many people in our community stepping up. This is the shareholders stepping up. Meantime, we've got, the bears and the Qs. They're out looking out for blood. And you can see people like Ross Gerber just go completely crazy, saying really weird things. And then you've got this ex-board member of Tesla, what is his name? Steve Wesley, who is saying incredibly negative things about this vote, saying that he doesn't think that Elon deserves it. This is somebody who was a board member for Tesla, who's now turned on him. They obviously have bad blood against each other. Otherwise, he wouldn't be saying these things, because everything he said had nothing. He was talking about the future, not about the past, of whether or not he should have reserved the compensation at this point. Any comments on this?
Yeah, I mean,
Cynical.
I commented on the. I'm sorry, Richard. I was just going to say that I commented on this originally. It did, when you hear the bears talk about this and you A/B test their it doesn't pass the common sense test. So the example he brought up is like, well, look, Tesla's growth has slowed. It was 71% in this year, it was 50% the next year. I mean, these are astronomical growth numbers, and now the growth numbers have slowed for the last year. So he's not deserving of a compensation package that was contrived 6 years ago for that is since 11x'd for shareholders. It doesn't pass the common sense test. If you took that filter and applied it to other other CEOs of other companies that have single digit growth or flat growth over 2022 to 2023. Apple's one of them. Microsoft was single digit growth between those last two full financial years. You would be having the same conversation about them. So it doesn't pass the common sense test. It looks like, he may have been booted out of, being, a board member before, a lot of the compensation for board members really started escalating. So, there could be some bad blood, but you have to go back and just run the common sense test filter on their statements, and it doesn't pass the common sense test. The same thing with Ross's comment. Like, Ross is now commenting on silicon procurement and how that should work. Don't listen to these people that don't have the expertise and don't understand it. Go seek out people with expertise. That's why we have Richard on this show today to have this conversation. I just wanted to make some comments on that. Just ridiculous. And they just don't pass the common sense test.
I agree. And the other thing you have to know is people also have positions. They have positions puts or whatever it is. So they may have an interest in influencing this vote because they have a megaphone. It drives me crazy every time when Ross is saying that, he has these millions of shares. He does not. His fund has 800 shares today, 800. Right? I'm sure each and every one of us has more. And the money he manages, he actually calls around people telling to sell Tesla, and they're not. They're not. His clients don't listen to him. They keep their Tesla shares. We see it every 3 months in the SEC filings. And I know for a fact that he calls them and tells them sell, sell, sell. And then they call him back and say, no, we're not going to sell. So he has no influence on them. He has no voting rights for these. He does have no rights to vote for any of the shares of his clients. All these voting rights are with the clients themselves. So he's parading there as if he has a lot of shares, as if he has influence on a lot of shares. He does not. And that he knows about Tesla's business, he does not. And that, this whole vote, he's voting no, and he's trying to influence everybody else to vote no. Tesla is today, if I recall it right, he has 31 positions in his fund. Tesla is position 28. So it's really, one of the last things that he still has shares for. Just forget about it. You don't listen. It's a waste of your time. It's a waste of your brain cells to do so, and don't do it.
Richard.
Yeah, I know, Herbert. You want me to be nice on your show, and there I go again.
I was going to say, cynical me believes it's usually a reflection upon their financial activity in that security at that time. And especially if they're running a fund and it's short term and they bought at the wrong time, theoretically, and they're underwater, it's reflected in how they respond. Because usually,
and don't you think this should be disclosed? Yeah, don't you think it should be disclosed? I don't think anybody should be allowed to speak on CNBC without showing the disclosure on what impact and what current positions they have. That's the only way.
There's another comment today too, that a lot of the institutions voting against, if you look at their position, they're mostly underweight in Tesla, which essentially means that they're short. And one of their ways to potentially get to equal weight eventually would be to get the stock price to come down so they can acquire more. So I think you really have to go back and understand the origins. And that's why I said there's a lot of bizarre behavior. There's always bizarre behavior on X, but man, when that article came out from CNBC this week, you saw people coming out of the woodworks of like, oh my God, if this is true, like not even trying to understand how silicon allocation actually works, just trying to blow it up into like some big issue, and they're still trying to do it. And to me, it exposed a number of people and what they may be doing or transacting in the background.
And let me recall it a little bit what happened in 2018. In 2018, at the moment of this vote, Tesla was the most shorted stock, 22% short, right? At the same time, it was a vote where 70% were institutionals and only 30% retail, so much less favorable to Tesla. Of those institutionals, some were very vocal about how they hated the whole situation and everything. Glass Lewis and ISS both came out and said no, against, right? In that situation, loads of shorts, like 10 times the shorts we have now. 70% institutionals. We have now 52.5% of the voting, of the casted votes that are institutional. So we're far lower, much stronger retail base now. And at the same time, you know, a complete public appearance of this is not possible, this should not be possible, Elon will never succeed. That was the mood. And what was the result? 73%. Now, we're re-voting on that. We know he accomplished it. We all have the feeling a deal is a deal. We're now 52% institutionals, 47.5% retail. Short sellers are only 2% and even. So we're today in a much stronger position, and we're voting on something that we know has been accomplished. I mean, it should actually, you're completely right, Jeff, it should be a no-brainer. I mean, anybody who has 2 brain cells between the ears should know that this has to be for. But then people are frustrated. People are frustrated with the stock price. People are frustrated with Elon's behavior on politics and whatever else. And they feel they can, you know, be mean. This is the middle school little girl being mean complex of let's now do something. Maybe it will succeed. And I just don't think there's enough mean people in this world. I remain optimistic that people have brain and are not mean.
Okay.
Usually a good combination.
This is the opportunity for the retail shareholders to step up, you know, vote, get out there, because we need to take control of this and don't let institutions to decide our fate. This is the opportunity. Just like what happened in GameStop, let's show these guys what can happen. Any other comments, Richard? Any final thoughts?
Yeah, just to let you know, I'm involved in 2 other securities where shareholders collectively are trying to act for the benefit of everyone. So it's not the only one, and it seems to be something that is going to be more prevalent, because it may be the only way we could exert any influence at all is by collectively getting together for the collective benefit of all shareholders.
Your cases are in California, I imagine, right? Because you're in California and these are always state cases, right?
Well, me personally, yes. I was talking about the securities themselves. They're, you know, small securities that are involved they're at the SEC and FINRA. That's the issue, and congressional. But the issue is a lot of the same issues, just like trying to get voting, right? Getting voting done. There are all kinds of mechanical issues that disfavor retail traders, and there's no way of correcting them. It's all throughout. We kind of just take it for granted. It is what it is, and there's not many ways you can influence. But what you did, like getting all those people together, submitting those letters, that really influenced the case, because it's part of the record. It obviously is considered. Maybe we don't consider it for a great, but we certainly consider it. We know there's a lot of people looking at this thing. So it really is influential, and that's really a positive step towards retail getting more, more of a fair shake.
And I actually wonder how it came that she changed her mind. What was it? Because she obviously had no intention to make these public record,
right.
And now they are, and they did a heck of a work. If you read the accompanying procedure, how it happened, to make sure that these are only real shareholders. I know for 2-3 people that signed, but they were actually not shareholders, and they arbitrarily looked for a date. I think it was in July last year. I mean, why they took July? Maybe that's the listing that Broadridge had, or I don't know how it worked, but they did a work on checking whether the letter corresponded to somebody who was a shareholder in July last year. That's a heck of a job. I mean that it's not easy to find people. I mean, not everybody put an address in. So
Right.
there were letters eliminated. That there were hours of work, and then they became public record. And I think it's not a surprise that she put it out at the very last moment, because we're expecting, like I said earlier, Tesla's response to the plaintiff's request for payment this week. So she waited until the last moment to do it, but she had to do it. So something must have happened where, she felt, I can't ignore it, even though I want to ignore it.
It definitely was a change from her earlier position. It was clear. I noticed that too. That stepped out. And it suggested that it was really getting consideration. Not that every letter was being read, obviously, but that the influence was felt.
Agree.
Well, I mean,
very
she had
proud of everybody who wrote the letter. Very proud.
zero evidence in her judgment that this comp package harmed the shareholders, and then here we are, the shareholders stepping up, saying we weren't harmed, we weren't duped, we knew exactly what was happening. We were so happy that this incredible package came out. This offering was amazing, right? And zero, you get paid nothing unless you accomplish what we.
Well, I
make us
think
10x.
the wind turned from somewhere else. I think what happened is she realizes that she is single-handedly damaging,
America.
ruining, no, not America, but Delaware, because that's what she's in charge of. And I think what happened in the last couple of weeks is that law firms, maybe even politicians, must have reached out to her and told her, do you understand what you're doing? And so that may actually help us with the payment. That may help us in the appeal, but there is clearly a shift.
But I appreciate Jeff's upset over whatever it is. It's a windfall. It could be $500 in this case. It's a windfall. You as attorneys did nothing for the benefit of shareholders. Really. Maybe you could argue Tornetta, the shareholder, he's a beneficiary because he's going to get a bonus. So, okay, he benefited, but everybody else did not. And that's why I started off saying this is only about plaintiff's attorney's fees. That's it. That's all.
Well, if this happens and we pay $5 billion, I think Amy's share, she would have to pay $30,000 just for her because of the lawyer's legal fees. So we are all, it's actually the opposite. We are getting fleeced.
Yeah, just understand that if it's anything like that, it'll be appealed a couple times, and there's going to be no enforceable order until it gets all the way resolved. So
I don't think we'll end up with that much, and I don't think she will do it now. Yeah. I just have this net feeling that the wind has turned a little bit, not a lot, but and it's not because she suddenly fell in love with Elon. No. That's certainly not. But I think she gets resistance within Delaware telling her, look, you overstepped.
I think she's going to fall within the higher end of what Amy's lawyers said. So it might be slightly more, could be slightly
50
more.
50 million.
Yeah, it might be 50. But in that ballpark, and then and again, I think she thinks that might be a defensible number for her.
And the number where you're right, where the appeals court is not gonna completely go against her, right? I mean, right. 50 million, the appeal, and let me be very clear, if it is 50 million, in my view, the appeal shouldn't be on attorney fees. It should be on the case, on the fact that she made a judgment, say on the grounds that the board did not do their job, and that has to be wiped out. That is just not true, and you can't let that stand.
Yeah, of course, on appeal, everything just not that I'd be concerned about this, but if you appeal, there's probably going to be a cross appeal also. So if they'll claim, so if we're just playing numbers. Let's say judge awards $45 million as attorney's fees, and Tesla challenges that because they challenged the decision. The plaintiffs would challenge it too because they'd say the attorney's fees were too small and she shouldn't have reduced it. So you'd still have that kind of battle. I don't think they'd win on that, but it would still be there.
I agree. And Amy's case and our letters are now part of both appeals. That's where we wanted to get. We wanted to make sure that the proofs, the sentiment, the disgust of the shareholders was recorded and part of documents that will be included in the appeal.
Yeah, it should be the way, right? For a public company, shouldn't shareholders have a way to individually express themselves to the court? Because they can't really otherwise. So that was a way really you could, without even having to read them, you could express the sentiment of the community.
Especially in this ridiculous case where the plaintiff only had 9 shares, right? If this would have been one of the major shareholders, be it. But I mean, a ridiculous guy who obviously was planted, or at least was found by an attorney who was really eager to bring a case against Tesla, because that's what it is. I mean, it's just the whole thing looks so constructed and so pulled together. It's horrible.
Well, I'm not a class action attorney, but in class actions, those firms, they might throw out 100, hit 2, and I hope they hit 2 big ones, and that's it. So most of it is in my opinion, most of it's garbage, and they just hope.
Yeah, completely agree.
So this is all in the backdrop, right? It's just absolutely mind-boggling this is even happening when Elon not only already showed that he took the $50 billion company to over $1 trillion, and then now we're at around 600 billion. But now we're in the brink of FSD. We're in the brink of 8.8. And so I wanted to just end it with taking a look at this tweet, this post that Elon just did a few days ago. He said this: the 12.4.1 releases today to Tesla employees. If that goes well, it's going to be released to a limited number of external customers this weekend. So that's a few, this weekend. There are a massive number of changes to this build. It should arguably be called V13, but we're sticking to 12. Okay, he said this many times before, but the big statements he made, 2 other versions are in earlier stages of testing, 12.5 and 6. He said this could be arguably called version 14 and 15. So that's a little bit of a hint that he thinks that 12.5 is as big as the jump from 12 to 12.4, 11 to 12. And then we're starting to get, this is the big statement, we are starting to get to the point where once known bugs are fixed, it will take over a year of driving to get even one intervention. Wow. 1 year of driving to get one intervention, and we already know what the bugs are. We're starting to get there, not saying that it's done. So I've had this big live show talking about this. I think this is a big, statement. This shows confidence that we are headed in the direction. It shows that he knows what the bugs are that they need to fix. But this number, 1 year of driving to get even one intervention, this is the metric that we've been waiting to hear. It's one thing for them to say that it's safer than a human. It's one thing to say, oh, it's 4 to 5 times better than the previous version. It's another thing to say that we are eventually, at some point, we're going to get to 1 year driving before you get one intervention. This is miles driven per intervention. So what was your thoughts, Jeff, when you saw this?
Yeah, there's a lot of detail in that message. There's also a lot of qualifiers, just to take the other side of it. So Tesla has information that none of us as, FSD beta testers or retail investors or any would see or understand. They've got a dashboard of information as they're constructing these releases. They're putting them through unit tests. They're putting them through system tests. They're putting them through drive testing. They have simulators. They have accelerators. They have an ability to basically gather a data set and use these accelerators. You're trying to really understand corner cases, edge cases. You're trying to make sure you fix known bugs, and you're trying to also, make sure that you haven't introduced new bugs. So what I would like to see from Tesla is I'd like to see them converge on a release that is at least quote unquote feature complete, where they say like, look, we've integrated everything. And in classic software development, that's where you really get a lot of the bug drive down curve occurring, because you're not introducing new variables in that could be disruptive, that could cause other bugs. So I think it's important for Tesla to get to that point of being fully feature complete. That's why I believe they need a 12.4, 12.5, a 12.6. Not saying that they're not going to introduce other features later down the line, but basically getting the major features in the release so there's some level of stability. And it's important. I think Elon referenced that there were a lot of changes from 12.3.6 to 12.4.1. And it could have arguably be called a version 13. So when I hear that, with a quality background, manufacturing, I hear a lot of changes means a lot of potential instability. And I think that may have been some of the delay of getting this release out to employees and eventually consumers, is that just the rate of change or the number of changes. So in summary, you really want to converge to get the feature complete. You want to get the number of changes to be reduced. You want to get the opens, the number of new opens on the bug curve to come down, and that's how you'll know you're really converging. But I believe, back to Elon's points, I believe that they're seeing something in their lab testing that's pointing to the fact that they've made significant progress in terms of their own A/B testing in the lab of like, hey, I ran 12.36 through these accelerators, through these simulators, and I got this. And now I've run 12.4, 12.41, maybe even 12.5 through them, and now I'm seeing this. And I believe that's what Elon's referring to. Devil's in the detail. You need to get it out to a lot of users. You need to see a lot of people driving it. And then I think you can really start gaining more confidence in it.
Thank you, Jeff. Alexandra, I know you were in Europe. You've been busy with this case. Did you see this tweet? Because you better have seen this tweet. This is a big one.
I saw the tweet, but I have to say, I get bombarded with people who don't know how to vote or who have issues with the vote. I am busy, and I promise it's at 3 p.m. that it starts, and then I open my emails, I open LinkedIn. It comes from all sides, and obviously DMs on X. So I grab from time to time, actually, thanks to our DMs, the most important stuff. But other than that, it's been something that I was for more than an hour in an interview with Reuters, who tried to spin this, and I hope I set the record right, because they come into these interviews with the attitude of get you, right? I get you, and so. Good thing I'm used to that. 20 years ago, when I did a lot of press, I had a lot of training. Moody's was training the analysts of how to work with journalists. So I feel I'm not going there unprepared, but it's always a challenge. So no, I have to admit, I know you also want to talk about financing and all that. I'm out of it for the moment. Next Thursday, I will be back to my normal self. But I want to just thank Jeff also publicly, because Jeff was the first one to get the invitation, and he kindly proposed me his +1, which I had the honor to accept. And I just think, Cyber Bulls is something. We're a really very special family.
Well, this is the point, right? We've got the shareholder meeting. This is big. We're all working really hard. You, Amy, of course, just tremendous job. And then we're at the brink. We're going to go in 8.8. He's going to talk about driverless cars, autonomous cars, picking us up and driving us around. It may not happen 8.8. It's going to happen a year, 2 years from now, but we're heading in that direction. Here we are deciding whether or not we should be compensating the man that's taken us all the way here, the person who's the brainchild of it, bring together the team that's doing this. So I just wanted to bring this up because it's a juxtaposition of why the hell are we even debating this at this point? It's so ridiculous. But we have to deal with it.
The board needs to figure this out. The board needs to make sure not only is Elon compensated for his prior work, but that he's properly motivated for the next decade. That is the job of the board of directors to do that. They need to figure this out and get it done.
Okay. Thank you so much, Richard. Appreciate you joining us. Your expertise and backdrop explained to everything to us was important. Alexandra, thank you for all the work you do. And then Jeff, you are the Jeff Lutz. And very well respected.
For your name.
And thank you, all three of you. I always enjoy all three of you, and I appreciate the opportunity to be here.
Thank you.
And thank
Thanks,
you for
Richard.
always being there for all my questions, Richard. I bombard you with all this crap all the time. You've been very patient with me. Thank you so much.
Thanks, everybody. Okay, bye-bye. I've created a website that is the most comprehensive resource for the Tesla investor. Please check it out. Simply go to my website at herbertong.com.